everybody. My name is Nicoletti. I'm an attorney in Jacksonville, Florida. Today, I want to cover the different types of property where probate is needed. So, we'll back up to the definition of probate, and that is where somebody owned real estate, they died, and to transfer title to the rightful heirs, there needs to be this court process that's opened, formal papers are signed by the judge that transfers the title to the heirs. Now, there's certain kinds of property where that probate is going to be needed. If there is no trust the property's titled in, no life estate ladybird, no types of husband and wife situations, you're going to need probates on these certain kinds. Now, back in 08, 07, where all the loans were screwy Louie Dewey, you had situations where only the husband was on the deed, or only the wife was on the deed. Now, where that comes into play is if that only husband is dead and dies and the wife is still alive, she doesn't automatically get that title to the property. She would need to go through probate. Vice versa. Wife was the only one on the deed and she dies and husband's still alive. If he ever wanted to sell, convey, transfer, transfer to an investor, sell it, they need to go through probate. It's crazy because we'll get into another video about how if it's titled husband and wife and husband dies, it all goes to wife. And then if wife dies from there, you'll need a probate. Also, another one is tenants in common. So you may have A, B, C, and D, and they all own it as different interests on the property. Just 25%, 25%, 25%, 25%. If one of them dies, the interest of that person that dies does not automatically transfer to the other three. It actually would go to that person's heirs. So be aware that if there's property titled as tenants in common, A, B, C, and D, one of them dies, you're going to need to do a probate for A. Now imagine if A, B, and C are all dead, D's the only one alive, comes to you, the realtor, the investor, I want to sell, I want to list, and you're going to go, well, hold on a second. After watching Al's video, there's 3 people that are deceased on title. How was the deed titled? It doesn't look like it's a tenancy by entirety. It doesn't look like it's joint tenants with the right of survivorship. We may have a tenants in common issue. We may need to do a probate for all 3 of those interests. It's crazy, but it's needed. I've even seen recently where you had A, B, and C, and A was deceased, B and C were alive. They were approached by the investor, the realtor, and they wanted to sell. And believe it or not, they couldn't without going through the probate of A. And what they found out was that it didn't go to them. A's interest doesn't go to them. It goes to A's heirs. And again, we'll cover the different ways where property is not subject to probate, where it doesn't have to go through probate. But these are some just common ways that we see it where a probate is needed on property in the way it is titled.